Hello and welcome to the IPC's webinar on the do's and don'ts of video surveillance. As part of our mandate, the IPC provides guidance on Ontario's public sector access and privacy legislation. These laws are the Freedom of Information and Protection of Privacy Act and the Municipal Freedom of Information and Protection of Privacy Act. Today we will be discussing your institution's obligations under these acts when it comes to video surveillance. We will also be sharing some best practices. Video surveillance programs are mainly used for public safety reasons, to detect illegal activity, and to assist in any follow-up investigations. They may also act as a deterrent. While video surveillance may enhance public safety, it also poses risks to the privacy of individuals whose personal information may be collected, used, and disclosed. Under Ontario's privacy laws, you should only resort to video surveillance if it can be justified. It is also critical to remember that individuals have a right to go about their daily lives free of widespread surveillance, including in public spaces. The feeling of being watched or monitored by the continuous gaze of video surveillance may have a chilling effect on law-abiding individuals, causing them to alter their behavior and limit the expression of their rights. This right to be free from constant surveillance, even in a public space, has been consistently acknowledged by our courts, including the Supreme Court of Canada. With the many privacy risks arising from the potential for excessive use of video surveillance, special care must be taken when considering whether and how to use this technology. How can your institution ensure that its video surveillance program complies with Ontario's access and privacy laws and protects the privacy rights of Ontarians? When considering the use of video surveillance, you must first address whether the system will involve the collection of personal information. This will likely be the case in that most video surveillance systems collect personal information by capturing images of identifiable individuals. The next step is to determine whether your institution has the legal authority to collect personal information. In Ontario, institutions must meet at least one of three conditions in order to have this authority. The collection must be expressly authorized by statute, used for the purposes of law enforcement, or necessary to the proper administration of a lawfully authorized activity. Let's take a closer look at how each of these conditions may be met. The first condition speaks for itself. A statutory authority to collect personal information must be expressly authorized in specific terms within a law or regulation for this condition to apply. Therefore, if a law or regulation gives your institution the express authority to collect personal information through the use of video surveillance, you are expressly authorized to do so. This type of authorization is rare in Ontario. It is important to note, however, that an authority that is stated in non-specific terms would not be enough to be considered expressly authorized by statute. The second condition only applies to your institution if it has a clear law enforcement mandate. You cannot justify the collection of personal information by simply claiming to have a mere interest in policing or law enforcement investigations. Even if your institution has a clear law enforcement mandate, say you are a police service or a transit authority with special constable services, this is not an unconditional authority. Law enforcement officials are only authorized to collect personal information in cases where the collection furthers actual law enforcement purposes. For example, law enforcement officials may use video surveillance to monitor crowded areas linked to excessive drinking, violence, or other illegal activity. Which brings us to the third condition for the lawful collection of personal information, necessary to the proper administration of a lawfully authorized activity. To satisfy this condition, your institution must demonstrate two things. First, that the activity for which you collected personal information is lawfully authorized under a statute, regulation, bylaw, policy, or order. And second, that the collection of personal information is necessary to that lawfully authorized activity. Let's look at each of these in greater detail. In the case of video surveillance, a lawfully authorized activity will typically relate to the safe and secure operation of your buildings, facilities, or public space. For example, school boards are lawfully authorized to operate schools. As such, they may be able to justify the use of video surveillance on school properties as a way to ensure the safety of students and teachers. Likewise, a public transit authority is authorized to operate public transportation services and may be justified in using video surveillance cameras on buses and subway systems to ensure the safety of passengers and transit staff. The other critical element in determining whether you have the legal authority to collect personal information requires that the collection be necessary to the proper administration of that activity. Necessary here means more than merely helpful. If your institution collects personal information that is only helpful to the activity, it would not meet the necessary standard. How can your institution meet this standard? You will need to consider whether using video surveillance is necessary, as well as the sensitivity and amount of the personal information to be collected. In assessing whether you need video surveillance, first consider whether the underlying problem or concern you would like to address is real, substantial, and pressing. There should be specific incidents of crime or significant safety concerns that you need to address. A minor offense, such as littering, would generally not be considered a substantial or pressing problem that would call for the use of video surveillance. Second, determine if there are other, less intrusive and effective ways your institution can address the problem apart from video surveillance. For example, if a dimly lit area of a community center's parking lot is the site of ongoing vandalism, before it considers using video surveillance, the municipality should first evaluate the effectiveness of less intrusive alternatives, such as increased lighting in that area. Third, consider whether the benefits of video surveillance substantially outweigh the reduction in privacy. Institutions should also bear in mind the sensitivity of personal information they collect by means of video surveillance. The greater the sensitivity, the harder it is to justify video surveillance, even when it comes with clear benefits. In this regard, look at the nature of the space under surveillance and the closeness of the surveillance. Some spaces are considered to be more sensitive than others. For example, individuals have a high expectation of privacy in areas such as public washrooms. The sensitivity of these spaces is considered to be higher than that of open-air public spaces, such as public roads, parks, and squares, where individuals generally have a lower expectation of privacy. Still, even in a space in which there is a relatively lower expectation of privacy, sensitive personal information may be at issue. This is especially true if your video surveillance technology can zoom in, for example, on individuals sharing an intimate moment sitting on a park bench. Suddenly, the sensitivity of that space and the personal information collected in it would increase. Finally, consider the amount of personal information that you collect. Your institution must limit the amount of personal information it collects and retains through the use of video surveillance. One way to do this is by ensuring that the video camera does not capture information from adjacent buildings or properties. Instead, video cameras should only be installed in and directed at areas where the underlying problem or concern is present. Another example is to avoid the collection of audio in your surveillance program. In short, when it comes to your video surveillance program, a few things to remember are: do not deploy cameras except in relation to real, substantial, and pressing concerns. Ensure that cameras are not in areas where individuals have a higher expectation of privacy. And do not collect more personal information than you need. For example, disable or minimize any pan and zoom functions to avoid the over-collection of personal information. In Ontario, public institutions must notify individuals about the collection of their personal information. To provide effective notice in the case of video surveillance, you should prominently display signs with a clear, language-neutral graphic depicting the use of video surveillance within the monitored areas. These signs, or some other form of notice, including a notice on your institution's website, must describe the legal authority for the collection, the principal purpose or purposes for which you intend to use the personal information, and the title, business address, and telephone number of a primary contact in case there are any questions. Providing effective notice is contextual. Institutions should consider the audience and tailor the approach. For example, if the surveillance takes place in an area with a high concentration of visually impaired individuals, institutions should consider providing notice in an alternative form. An important aspect of managing a video surveillance program involves protecting personal information from misuse. Ontario's privacy laws restrict how personal information may be used once it has been collected. As a general rule, you should not use the information collected from video surveillance unless it is used for a purpose consistent with the original purpose of the surveillance program. In other words, you are generally not permitted to use video footage for other unrelated purposes. Let's look at a school to further illustrate this point. A security camera set up to monitor the entrance to a school to address security concerns will typically collect more information about the movements and activities of law-abiding individuals than information relating to a security incident. To avoid the risk of function creep, the school should not use the personal information collected by the security camera to monitor student attendance, for example, but it may use it in relation to a security incident. There are rules for when and in what situations your institution can disclose personal information captured by your video surveillance system, including disclosures to law enforcement agencies. Generally speaking, you should only disclose personal information to a law enforcement agency when required by law, such as in response to a court order. However, institutions have discretion to disclose personal information in other situations, such as where disclosure is made to aid an investigation and for health or safety reasons. For example, you may consider disclosing footage to a law enforcement agency on your own initiative where you have reasonable grounds to believe that an offense has occurred on your premises. Let's say you learn of an alleged assault on your property in an area monitored by video surveillance. Your institution is permitted to report the incident and disclose the footage to the police, but you should only disclose the information that appears to be relevant and necessary for the potential investigation. In all cases, you should make a careful assessment of the circumstances before deciding whether to disclose personal information to a law enforcement agency. When permitted under the law, it is important that you disclose personal information in a manner that protects the privacy and security of that information. If you do not already have them in place, develop policies to ensure that any disclosure of video complies with your lawful disclosure responsibilities. A good practice is to maintain a log of each disclosure that includes the date, time, and location of the footage, as well as the reason for the disclosure. Ontario's access and privacy laws also set out rules for the minimum length of time institutions must retain personal information. In general, you are required to retain personal information for at least 1 year after you have used it to give individuals to whom the information relates an opportunity to access it. Note that this retention requirement only applies to personal information that you have used. It does not apply to personal information that you have collected but not used. Personal information is considered to be used whenever it is accessed or disclosed. Simply viewing a live feed does not count as a use. To this end, any video footage you have collected but never used should be routinely erased according to a standard schedule. We recommend that unused videos be deleted within hours or days of the recording. When deciding how long to keep unused video, consider the amount of time reasonably necessary to discover or report an incident that occurred in the space under surveillance. Your security obligations under the law require you to protect personal information under your control from unauthorized access, destruction, or damage. In the context of video surveillance, this means that you must ensure the confidentiality, integrity, and availability of the footage captured by your system. To help you do this, define, document, and put in place measures to protect your video surveillance footage. A few measures to consider include strongly encrypting video surveillance footage both at rest and when transmitted across open public networks, storing physical records of footage, such as disks, memory cards, or servers, in a locked facility, limiting staff and other people's access to footage to a need-to-know basis, storing monitors in a secured location where they are not visible to the public, regularly updating systems and applications to protect against vulnerabilities, and keeping auditable logs of all accesses, uses, and disclosures of footage that are generated automatically where records are maintained electronically. Fulfilling your security obligations requires collaboration. You may need to consult with the system provider and/or technical staff to implement some of these measures. Now that we've covered your video surveillance obligations under Ontario's access and privacy laws, let's turn our focus to 5 best practices that will help you protect people's privacy. Privacy Impact Assessment, or PIA, is a basic and essential tool that will help you identify, then mitigate, the potential privacy risks of a program you are developing, such as video surveillance. By conducting a PIA, you will be able to address issues such as the lawfulness of the collection, use, or disclosure of personal information. A PIA will also identify safeguards you could or must adopt to eliminate or reduce the risks. In turn, you can incorporate these safeguards into your institution's policies and procedures on video surveillance. It is important that you conduct a PIA before your institution begins using video surveillance. You should also review your PIA when you make significant changes to the program. Your institution should consult with individuals who would likely be the most affected by surveillance in a certain area. It would benefit your institution to find out about the need for video surveillance and the impact of its proposed use on the public. This consultation will provide people with an opportunity to comment on the specifics of the program, including the location of cameras and the use of video surveillance itself. Ontario's access and privacy laws require that you define, document, and establish measures to safeguard your video footage. You should also update your policies when you make significant changes to the program. For example, when you upgrade equipment. These policies may include details such as the rationale, objectives, and justification for implementing the program. You should also consider making these policies available to the public. You are responsible for training employees to ensure that they understand their duties with regard to your institution's video surveillance program. Educating your employees on their responsibilities is an essential step to achieving an effective program that complies with our access and privacy laws. We recommend employees attend an initial privacy orientation followed by regular training sessions. This training should include detailed information on your institution's policies and the obligations arising from them. Make sure you regularly audit the roles, responsibilities, and practices of your institution's video surveillance program. This will ensure that they are in line with your policies. Also, reevaluate the need for a video surveillance program regularly to determine whether it remains justified. It is important that you address any concerns identified in your audit in a timely fashion, in some cases immediately. Let employees know that their job activities may be subject to an audit, and inform them that they may be asked to justify particular instances where they accessed video footage. Finally, in the interest of transparency, consider making the findings of your audit available to the public, just as you would your policies. Video surveillance technologies continue to evolve, as do public expectations surrounding their use. The focus of this webinar has been on the various issues, requirements, and best practices for video surveillance. Other forms of surveillance, including automated license plate recognition, or ALPR, and body-worn cameras, raise additional privacy issues that require additional safeguards and controls. Please see our guidance on ALPR and body-worn cameras for more information about these surveillance technologies. Ontario's access and privacy laws strongly support the proposition that the public has an expectation that they will not be subject to extensive surveillance. Your institution must ensure that the public receives the benefits associated with video surveillance technologies while continuing to provide strong privacy protections owed to all citizens. A video surveillance program that protects individual privacy will help to mitigate privacy risks and help your institution meet its obligations under the law. Thank you for joining us today. We hope that you found this presentation helpful. Please see our video surveillance guidelines for more information on all topics discussed in this webinar. The IPC is committed to working with Ontario's public institutions, and we welcome you to contact us if you need additional guidance on video surveillance. And be sure to subscribe to our YouTube channel for all of our latest videos. Thank you very much.